Hi, I'm Nick Lee, Legal Director at Rosenblatt. Welcome to our 6-part training module on how to run your own claim on the small claims track. Over the course of this series, myself and my colleagues, Annabelle Morgan, Jack Bird, will cover everything you need to know to see a claim through from inception to a successful result. This training will be split into 6 chapters. Firstly, an introduction to the small claims track, which deals with claims worth up to £10,000 and preparations required. We'll then move on to drafting or receiving letters of claim and letters of response. Next up, we'll talk about how you go about starting or defending a claim. The next chapter will focus on the various forms required, how to prepare evidence, and options for settlement or mediation. We'll then put these preparations into action by discussing what to expect at a hearing. And lastly, the final chapter will cover enforcement of the judgment. In the English court system, there are various tracks for different values of claim. These are set out in the Civil Procedure Rules, also known as the Court Rules. The small claims track deals generally with claims up to a value of £10,000. They are principally addressed in Part 27 of the Court Rules, but there are other parts of the CPR that could also come into play when dealing with small claims. As it is generally not cost effective to instruct a lawyer to conduct a claim with a value of £10,000 or less, the small claims track is designed for people to run their own claims without need of lawyers. The purpose of this training session is to show you how to do that. A low value claim may not seem worthwhile pursuing. However, small claims can still involve the recovery of thousands of pounds you would not otherwise get back. And if your business were to pursue a number of small claims, the total sum you could recover could mount up to a very substantial figure. All of this recovered income would help your business's profitability. Costs in the small claims track are generally fixed, which means that the court is not able to order that the other party pay your costs of the proceedings in full, save in rare circumstances. As such, you will likely not be able to recover all or most of the costs of a lawyer, even if you do win, which is a very strong reason for you to try to conduct the small claims yourself. Lawyers can nonetheless be involved in small claims, either in running the case or assisting clients by providing high-level advice or dealing with specific questions in the background. Or you may wish to have a lawyer run the first couple of cases for you, so you can see how things work. If you want to bring a small claim or have to defend one, you will need to set out your claim or defence clearly. This talk focuses on disputes where one party owes the other money and has not paid up, despite allegedly being obliged to. However, the small claims track can also be used for claims related to things such as low-value personal injury claims and certain landlord and tenant disputes. The starting point, if you are the claimant, will be to consider why you say the other party owes you money and has failed to pay up, or, if you're the defendant, why the claimant is wrong to say you owe them money. Defendants should also consider if they have a claim of their own against the claimant, which would be a counterclaim. Pull together all of the key documents that you will need to make the claim or defend the claim, such as contracts, terms and conditions, invoices, emails between the parties, and any other documents you would want to rely on to prove or support your claim or defence. Make sure you've read all of the key documents and not missed anything that may alter your position or make it untenable. If the claim is based on a contract or terms and conditions, check to see if there is a clause governing how a dispute should be dealt with, as you may be required to take certain steps before being able to commence a claim, such as that disputes are first arbitrated by, for example, a barrister. Consider the likely position of the other party and if they have a point. In other words, would the court consider that you have been unreasonable in bringing or defending the claim? There is little point in bringing a claim that will not succeed. Equally, there is no point in defending a claim where, without question, you're liable. If the merits are more evenly balanced, due to the small value of the claim and the limited risk in terms of costs, you may be willing to take a chance. If you're a claimant, consider if the defendant would be good for the money if they were ordered to pay it by the court, i.e. do they have, or do they at least appear to have, any assets, such as cash, property, vehicles, that sort of thing. If the defendant is a company, you can check their most recent accounts at Companies House, which you can access online for free. If you have reason to think the defendant would not be able to pay, seriously consider not proceeding with the claim. Threats of enforcing a court order against the defendant, such as by making them bankrupt if they're an individual, or winding them up if they're a company, is a very powerful incentive for them to pay up. We'll discuss this later. Ultimately, you want your claim or defence to be based on solid ground. The court will only grant you the order you wish if you give it the means to do so.
Welcome back to our small claims training module. I'm Annabelle Morgan, a dispute resolution solicitor at Rosenblatt. In this session, we'll be covering letters of claim and responses which will initiate proceedings in the small claims track. The English court system is set up to encourage parties to try to resolve their dispute before the would-be claimant issues proceedings. This is done by correspondence before a claim is started. If you want to sue someone, you should therefore write to them first, setting out the legal basis for your claim, for example the relevant contractual terms, the factual details of the defendant's breach, the loss that you have suffered as a result of that breach, and a demand for payment within a reasonable time, such as 14 days from the date that your letter is sent. You should also include a warning that if they don't pay up, you will take them to court, and if you win and they don't pay the judgment order, you will seek to enforce the order against them, including by, if applicable, seeking their bankruptcy if the defendant is a person, or their winding up if the defendant is a company. The reality is, in a small claim, the letter of claim or letter of response might be a short email that covers some but not all of the necessary elements, and may warrant a response that seeks further clarification before the nature of the claim can be understood sufficiently to respond in full. If the other side pay up, then great. If they don't, it will be useful further down the line to show the court that you tried to resolve the matter without going to court initially. If the deadline in the letter of claim passes without a response, consider one more time if you do still want to sue them. A defendant who receives a letter of claim should write a letter of response to the claimant within the time frame set out in the letter of claim, if it is a reasonable deadline. If appropriate, a defendant can ask for more time to respond, but would need to be able to justify the request. The letter of response should set out why the claimant is wrong to allege they are owed money, with specific reference to what the letter of claim says, and any counterclaim that the defendant has against the claimant. The letter of response will set out the defendant's likely defence if you do sue them, so it's a useful way to determine how strong your claim is, and if you're the defendant, your defence. If the pre-action correspondent fails to resolve the dispute, then it will unfortunately be necessary to start the claim or to defend the claim that's brought against you.
Welcome back to our small claims training module. I'm Jacques Bird, dispute resolution solicitor at Rosenblatt. In this session, we will be covering the process of drafting, issuing and serving a claim, the next steps and the defence. To bring your claim, you will need to complete the claim form N1. The contents of the claim form should follow what you have said in your letter of claim if you have sent one. These include the party details, the court details, which we'll come back to in a moment, brief details of the claim, the value of the claim, and the court issue fee, which we'll also come back to. You can issue your claim either at the Civil National Business Centre or Money Claim online. You will need to pay a court fee. In the small claims track, issue fees start at £35 for a claim worth up to £300 and go up to £455 for a claim worth up to £10,000. The fee gets added on top of the amount you are claiming. Before issuing your claim, ensure that everything in the claim form is written clearly and makes sense. Check all of the details are correct, including the party names. Once you have prepared your claim form, send it to the court for issuing and pay the fee. The court will confirm when your claim has been issued and will provide you with a copy of the claim form marked with the court seal and the date it was issued. The claim is served on the defendant by the court. The claim document should specify the date by which the defendant has to respond. However, you can also send the claim to the defendant to make sure they have received it. Doing so, you should include a response pack. The response pack is composed of the following forms: the main document, Form N9, which includes acknowledgement of service, the notes for the defendant, Form N1C, the admission form for specified amounts, Form N9A, and the defence and counterclaim for specified amounts, Form N9B. A defendant has 14 days from the date of service of the claim in which to file and serve a defence. The claim documents may specify the deadline. A defendant can file an acknowledgement of service, which is in the response pack, to get an extra 14 days. The defence sets out the defendant's response to the claim and will likely follow the letter of response, if one was sent. The defence needs to be filed at court and served on the claimant within the deadline. If a defendant fails to file a defence within the deadline, that means they are in default and judgment may be entered against them. The court may issue an order to this effect. Enforcement action can be taken against the defendant on the basis of a default judgment order. The defendant can apply to have a default judgment set aside. Maybe they did not receive the claim, or there are other valid reasons why the court should allow the defendant to put in a defence despite the deadline having passed. If the court sets aside the default judgment, it will set a new deadline for the defendant to file their defence.
Welcome back to our small claims training module. I'm Annabelle Morgan, a dispute resolution solicitor at Rosenblatt. In this session, we will be covering the directions questionnaire, allocation to the small claims track, evidence, settlement, and mediation. When a defence is filed, the court sends out questionnaires to the parties to assist the court in setting directions for the conduct of the claim. This is Form N180. The parties need to consider if the claim can be resolved without a hearing, where the claim should take place, how many witnesses they intend to call, whether they need any expert evidence, and whether they wish to consider settling the claim by way of mediation. The parties provide the completed directions questionnaire to the court and to the other party. Once the court has received directions questionnaires from the parties, it will allocate the claim. If the court agrees that the small claims track is the appropriate track, it sends out a notice to the party to confirm this. That notice will include directions the court has set down, having reviewed the directions questionnaires. This will include relating to the filing of witness statements, expert reports if requested, the hearing date, and the duration of the hearing. The substance of your claim or defence will be the evidence you file at the court and serve on the other party. Evidence is useful to the court only insofar as it relates to the claim that's pleaded. In other words, what is said in the claim form and the defence. Evidence that does not help the court resolve the issues in dispute will not be permitted, including evidence designed or intended to embarrass the other party, but which is not material to the claim itself. Factual evidence includes witness statements, which set out your witness's version of events, contracts, terms and conditions or invoices, or documents that show what was actually happening at the time, such as emails in which key things were said or not said, photographs that show the condition of things, telephone records to show when calls did or did not take place, and the like. Expert evidence is used by the court to help it reach a judgment on matters beyond its expertise. For example, if a company's value is to be determined, expert valuers can provide a valuation of the company's share price on key dates. In the small claims track, there are likely to be limited circumstances in which it would be worthwhile obtaining expert evidence. The court rules say, Expert evidence must be restricted to what is really needed to resolve the dispute, that experts have a duty to assist the court on matters within their expertise, and that this duty overrides their duties to the parties instructing them or paying them. The court can also order that one expert is instructed for both parties. The parties can agree to settle the claim at any stage by making a without prejudice offer for a specific sum. This offer is made in full and final settlement of the claim, so this payment alone is all that will be necessary to conclude the claim. Settlement offers may need to take into account the other party's costs of the claim and any interest sought, as the other party might make this a requirement of the settlement. If the parties do agree to settle, they will need to inform the court that settlement has been reached so that the claim and any hearings can be taken out of the court's list. The Small Claims Track offers a specific small claims mediation service as a way of seeking to resolve the dispute without the parties needing to progress the claim to conclusion, which will cost time, if not money. A mediation in the Small Claims Track usually lasts for 1 hour and takes place over the telephone. During a mediation, the parties do not speak to each other directly. The mediator speaks to each party in turn and tries to broker a settlement between them, or at least narrow down the issues. Mediation takes place on a without prejudice basis, so what is said during the mediation process cannot be used against that party, either in open correspondence or before the court at a hearing.
Welcome back to our Small Claims training module. I'm Jacques Bird, Dispute Resolution Solicitor at Rosenblatt. In this session, we will be covering the hearing. If the parties are unable to resolve the matter by way of settlement or mediation, it will proceed to a hearing so that the court can resolve it. The hearing is likely to be in person, in either a court or the judge's room, although they can take place remotely. The claimant should put together a bundle for the court and the other party to use, which includes the claim form, defence and any evidence. However, the court is lenient as to exactly how the bundle is prepared, as long as the documents it needs to rely on are present and the other party has them. At the hearing, the judge will consider the claim and the evidence. Witnesses should attend in case the judge has questions for them, so too an expert if permission was given for expert evidence to be used. At the hearing, you should dress smartly, make sure you have read all of the documents each party has filed, follow the proceedings carefully, answer any questions asked by the judge or the other party, if the judge allows, in a clear and concise manner, remain composed at all times and be polite to your opponent. And lastly, make a verbatim note of any judgment made by the judge so you can refer to it after the hearing as a record of why the judge reached the decision they did. After the judge has had the opportunity to consider the matter in full, they will deliver a judgment. This will be formalised in a court order that will be provided to the parties. A hearing can be used as a preliminary hearing if the defendant is a litigant in person and has not provided a defence that is sufficiently detailed. The actual hearing will be rescheduled so the proceedings can take place in better shape than they would otherwise have been. Whereas large value claims can justify the costs of lawyers, it is not commercially sensible to incur a large legal bill when seeking small sums, hence this training. Some costs are recoverable in the small claims jurisdiction on a fixed basis, however they are very limited to ensure that costs do not become disproportionate. Recoverable costs are solicitors' costs of up to £260, court fees, certain travel and accommodation expenses incurred attending hearings, fixed sums for loss of earnings or holiday entitlement as a consequence of attending hearings, limited to a maximum of £95 per person per day, and fixed sums for experts' fees, £750 for each expert. The court can award costs based on the unreasonable behaviour of the other party in certain circumstances. You can bring an appeal in the small claims track. However, this will involve time and further court fees. There's very limited recovery of costs incurred in bringing an appeal. The court has jurisdiction to set aside an earlier judgment and have a rehearing. For example, if the earlier judgment was entered against the wrong corporate entity. Liability for the other side's costs arising from discontinuance does not apply in the small claims track.
Welcome back to our small claims training module. I'm Nick Lee. In this session, we'll be covering enforcement before summarising the contents of this module. Having brought your claim and been granted judgment in your favour, well done! It may be the defendant does not comply with the order. If so, you will need to take enforcement action. A judgment is a debt, and where a defendant has failed to pay a judgment within the appropriate time frame, a claimant can take steps to enforce payment of that debt, including, for example, by an attachment of earnings order, which is where a creditor applies to court for an order to allow them to take funds direct from the debtor's wages, by taking control of the debtor's goods themselves, or by appointing an enforcement officer to take control of the debtor's goods and selling the items to cover the judgment debt. If the criteria is met, a creditor can also threaten to make a defendant bankrupt or wind up a defendant company. In order to make someone bankrupt, the debt must be at least £5,000. However, in the case of a company, the outstanding sum needs only to be £750. Although the insolvency processes are slightly different, they each work the same. You serve a statutory demand, which gives the defendant 3 weeks to pay, and if they do not, you are then able to start insolvency proceedings against them. Enforcement can become complicated, so you must be mindful not to get involved in a process that becomes disproportionately expensive. However, the threat of proceeding to make someone bankrupt or a company insolvent can be a very powerful incentive for the defendant to take you seriously. And if you have taken care to see if the defendant does have the means to pay a debt, they will in many cases do so without the need of further action. The purpose of this training has been to provide you with the tools you need to run your own small claims without a lawyer. The risks are relatively low, as not much money is at stake. However, if you have a number of people who owe you thousands of pounds, this can mount up significantly. The court system is there to help people get justice, and justice on a small scale is still justice. We have covered a lot of ground in this training. There is much more we can talk about. If you would like us to come and present the training in person, we would be delighted to do so. We will be able to expand upon some of the things we've only been able to touch on in this training and answer your questions directly. Thank you to my colleagues Annabelle and Jack for their assistance, and thank you for watching. We hope you found this series useful.